The United States Supreme Court declined to review a major election case involving who has the legal authority to enforce certain provisions of the Voting Rights Act. By denying review in this case, the Supreme Court left in place a highly contested ruling from the Eighth Circuit Court of Appeals. This denial leaves a distinct split in place between how federal voting laws are enforced in the Eighth Circuit compared to the rest of the country. Today, we're going to look at what happened in this case, the legal arguments from both sides, and why this procedural question has divided federal judges. We're also going to talk about how this denial by the Supreme Court may impact the upcoming elections nationwide. Now, before we jump into what the Supreme Court did in this ruling, if you like this type of content and you want to make sure you get it going forward, make sure to turn on all notifications, hit the subscribe button to ensure you never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. And right now, if you use my link down below and you use my exclusive code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee. Now, to understand how this case reached the Supreme Court, we have to look at the underlying conflict between Arkansas state's law and also a federal law. Arkansas passed a statute establishing that an individual cannot assist more than 6 voters in marking or casting a ballot during an election. Assisting a 7th person triggers a Class A misdemeanor under that state law. The state's rationale for these kinds of caps on help for voting is typically rooted in election administration, preventing improper influence, and maintaining order at the polling places. However, Section 208 of the Federal Voting Rights Act states that any voter who requires assistance due to blindness, disability, or an inability to read or write may be assisted by a person of the voter's choice, with narrow exceptions like an employer or a union officer. An organization called Arkansas United, which provides bilingual volunteers to help non-English proficient voters, filed a lawsuit against this Arkansas law. They argue that the state's 6-voter cap directly conflicted with broad assistance guarantees of federal laws, stating that they had to turn away voters during the 2020 election to avoid criminal liability, and that they will have to do the same thing for the upcoming elections. The federal district court who reviewed this case initially agreed with those plaintiffs, ruling that the federal law preempted the state cap under the Supremacy Clause. The state appealed in response to that district court ruling, and on review, the Eighth Circuit Court of Appeals didn't rule on whether the 6-voter cap itself was valid. Instead, they focused entirely on the threshold procedural question. Do private groups even have the legal standing to bring a lawsuit under Section 208? The Eighth Circuit panel ruled that they do not. The court's argument relies on a strict textualist and structural interpretation of federal statutes. They pointed out that while the text of the Voting Rights Act explicitly guarantees the U.S. Attorney General the power to actually bring the enforcement actions and lawsuits, it does not explicitly state that private citizens can do the same. Under standard statutory construction, if Congress explicitly names one party to enforce a law, courts generally assume Congress intended to exclude others. Therefore, the Eighth Circuit concluded that enforcing Section 208 is strictly the responsibility of the executive branch, not private litigants like the groups here, Arkansas United. Now, on the other side of the debate, the plaintiffs had several dissenting judges argue that this interpretation upends decades of legal precedent. Their argument is that for over half a century, the vast majority of Voting Rights Act enforcement has been carried out by private individuals and civil rights groups, with courts universally recognizing their right to bring these lawsuits. They contend that Congress passed the Voting Rights Act with the implied understanding that private citizens would act on their own to ensure the law was enforced, especially given the limited resources of the DOJ. This disagreement has created a sharp circuit split in the United States. The Fifth and the Sixth Circuits, along with numerous district courts across the nation, have previously allowed private plaintiffs to bring Section 208 claims. Within the Eighth Circuit itself, Chief Judge Colton dissented, arguing that the panel's decision deviated from historical practices and the broader consensus of federal jurisprudence. That ruling by the Eighth Circuit then led the group to file for Supreme Court review. They argued that the Supreme Court must grant review to the case because the Eighth Circuit's decision created a direct and stark conflict with settled precedent from other federal appellate courts, such as the Fifth Circuit and the Sixth Circuit, which have long permitted private enforcement of Section 208. They contended that leaving this circuit split unresolved would result in a fractured system where federal voting protections are administered differently based solely on geography and based on what state you're in. Furthermore, this group here argued that the panel's strict textualist approach departed from decades of established practices, and that stripping private litigants of standing would severely undermine these types of enforcements of the law. They argued without assistance from groups like theirs, these vulnerable voters would be exclusively dependent on the limited resources of the federal government at those polling places. However, in response to all of this, we got the decision from the Supreme Court, and they denied review to this case. By denying cert to this case, the Supreme Court has chosen not to resolve this split for the time being. The practical result of that is that in states like Arkansas, Missouri, Iowa, and Nebraska, any challenges to voter assistance laws under Section 208 must be initiated by the federal government itself. In other parts of the country, private lawsuits may still remain a valid avenue, and also this means now that Arkansas's law that they put in place will likely be enforceable for the upcoming election cycle. So the denial by the Supreme Court has major implications for the 8th Circuit in those states going forward, and also for the election law that was put in place by Arkansas, especially for this upcoming election. So what are your thoughts on that 8th Circuit ruling? What are your thoughts on this Arkansas law and the procedural finding that was used to actually dismiss this case? Leave your thoughts down in the comment section below and let me know what you think about this going forward. If you like this type of content and you want to make sure you get it going forward, make sure to like, comment, and subscribe, and turn on all notifications to never miss these videos when I release them. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.